sir. Please have a seat. Now I would like to invite Advocate Anirudh Yadav sir to give detailed information about the Se Humdard Tak Trust and detailed information as well as working of our trust.
आप सभी को नमस्कार। दर से हमदर्द तक इस ट्रस्ट की स्थापना 2021 में दिल्ली में की गई थी। इस ट्रस्ट की स्थापना हमारे जो सीनियर है परम आदरणीय एडवोकेट श्री रविंद्र जी लोखंडे सर, एडवोकेट श्री प्रकाश जी सालसिंगीकर सर, एडवोकेट श्रीमती सुनीता सालसिंगीकर मैडम के द्वारा इस ट्रस्ट की स्थापना की गई थी। यहाँ पर बैठे हुए सभी लोग सोचते होंगे कि इस ट्रस्ट की स्थापना के पीछे का मेन मकसद, मुख्य मकसद क्या है। तो दोस्तों, इस ट्रस्ट की स्थापना के पीछे का मुख्य मकसद था, देश हमें देता है सब कुछ, हम भी तो कुछ देना सीखें। देश से तो हमें बहुत कुछ मिल रहा है, हम अपनी सोसाइटी को क्या रिटर्न में दे सकते हैं, उस मकसद के साथ में हमारे सीनियर्स ने इस ट्रस्ट की स्थापना की थी। आज आप सभी को बताते हुए यह बहुत खुशी हो रही है कि दर से हमदर्द तक ट्रस्ट ने अब तक महाराष्ट्र के विभिन्न जेलों में बंद 525 कैदियों को जेल से बाहर आने में मदद की है, उनके जीवन में बदलाव लाने की एक शुरुआत की है। दर से हमदर्द तक का काम आप लोगों ने अभी इस एक महीने के सेशन में कई बार सुना होगा। दर से हमदर्द तक यह ट्रस्ट क्या करती है। दर से हमदर्द तक इस ट्रस्ट का काम जेल के अंदर से कैदी को सिर्फ बाहर निकालने तक सीमित नहीं है, जेल से बाहर निकालने तक सीमित नहीं है। मैं एक ऐसे केस का जिक्र करना चाहूंगा जिसमें एक युवा लड़का थाने सेंट्रल जेल में बंद था। जब हमारे दर से वॉलंटियर एडवोकेट ओमकार पाटिल थाने सेंट्रल प्रिजन में जाते हैं और उन्हें जब पता चलता है कि यह लड़का कारण सिर्फ इसलिए जेल में बंद है क्योंकि इस लड़के का जिस महिला के साथ में प्रेम संबंध था, उस महिला ने उसके ऊपर दबाव बनाया था कि आप अपना धर्म बदलकर मेरे साथ शादी कर लें। उस लड़के का यह कहना था कि मैं अपने धर्म में रहूंगा और मैं आपको भी अपने साथ रखूंगा। कुछ कारणवश उनका विवाद होता है, केस दर्ज होती है। उस लड़के का कोई परिवार नहीं होता है, इस वजह से केस दर्ज होने के बाद में वह किसी एडवोकेट को अपॉइंट नहीं कर पाता है और थाने सेंट्रल जेल में लगभग 2 वर्षों तक बंद रहता है। जब जेल के सुपरिटेंडेंट हमारे एडवोकेट ओमकार पाटिल साहब को बताते हैं तो एडवोकेट ओमकार पाटिल साहब उस लड़के की पूरी मदद करते हैं। मदद करने के बाद में जब वह व्यक्ति जेल से बाहर आता है तो रक्षाबंधन के त्योहार के दिन उसे यह इच्छा रहती है कि आज रक्षाबंधन था, अगर मैं जेल से बाहर आया हूं तो मेरी भी कोई बहन होती तो मुझे राखी बांधती थी। दर से हमदर्द तक ने दोस्तों अपने वॉलंटियर्स के माध्यम से उसकी यह भी कमी पूरी की और उसके हाथों पर राखी, कलाई पर राखी बनवा कर उसकी यह भी इच्छा पूरी की। और दर से हमदर्द तक के माध्यम से आज वह एक अच्छी होटल में काम कर रहा है और अपना जो खर्च है वह खुद वहन करता है और ऐसे और लोगों की मदद करने की कोशिश करता है। इससे बहुत सारे हैं, लेकिन कुछ चीजें हैं जिन्हें बताना आज के दिन बहुत जरूरी है। दर से हमदर्द तक संस्था की एक और कहानी ऐसी थी कि एक व्यक्ति था जो जब वह माइनर था उस वक्त उसके ऊपर एक केस रजिस्टर हो जाती है। पुलिस वालों के पास जब वह जाता है तो पुलिस वाले उससे कहते हैं कि अरे आपके ऊपर जो केस रजिस्टर थी वह केस तो खत्म हो चुकी है, आपका नाम उन लोगों ने वापस ले लिया है। वह संतुष्ट होकर अपने घर आ जाता है। घर आने के बाद में वह उस केस का जो ट्रायल रहता है वो चलता है। ट्रायल चलने के बाद में सडनली 2019 में पुलिस ऑफिसर्स उस व्यक्ति को अरेस्ट कर लेते हैं। अरेस्ट करने के बाद में उस वक्त अरेस्ट करते हैं जिस वक्त वह अच्छी तरीके से अपने परिवार को चलाते रहता है, अपने बच्चों की पढ़ाई लिखाई देखते रहता है। उस व्यक्ति को अरेस्ट करते हैं और जेल में डाल देते हैं। जेल में डालने की वजह से उस व्यक्ति के परिवार पर यह असर पड़ता है कि उसका जो बेटा रहता है वह बिगड़ जाता है, नशे की लत लग जाती है, बेटी की शादी नहीं हो पाती है। जब उसकी वाइफ उसे जेल में मिलने आती है और इन सारी चीजों के बारे में बताती है तो वह लाचार होने की वजह से उस जेल के अंदर आत्महत्या करने का प्रयत्न करता है। आत्महत्या का प्रयत्न करने के बावजूद भी उसने ट्यूबलाइट खाई, ट्यूबलाइट खाकर आत्महत्या करने का प्रयत्न किया। आत्महत्या करने से जब वह बच जाता है तो दोस्तों सुपरिटेंडेंट साहब के पास में एक ही नाम रहता है जो इस व्यक्ति की मदद कर सकता है, वह दर से हमदर्द तक रहता है। संपर्क करते हैं और वॉलंटियर उनके गांव तक जाते हैं, उनके जुर्माने होने का सबूत वगैरह लेकर आते हैं, उसे जेल से बाहर निकालते हैं। ऐसे बहुत से किस्से हैं, लेकिन आज हम सभी यहाँ पर रवि सर को सुनने के लिए जमा हुए हैं। तो मैं सर से गुजारिश करूंगा और रवि जी से गुजारिश करूंगा क्या कर सकते हैं।
Thank you, Anirudh sir, for making us familiar about the working as well as achievement of Se Humdard Tak Trust. Now, I would like to invite Sneha Verma to please introduce our esteemed chief guest.
Good afternoon, everyone. I would like to introduce our today's esteemed guest, Mr. Sudeep Pasbola. Mr. Sudeep Pasbola is a leading criminal defense attorney in Mumbai. Sir completed his membership to the Maharashtra Bar Council on September 19, 1987. Sir has been practicing in this field for more than 30 years now, with his cases finding coverage in the headlines and newspaper. Some familiar ones are the Rahul Gandhi defamation case, the Ilkar Parishad case, the sensational B. Blunt murder case, the Kamla Mills fire case, and the most renowned of them of all, the ongoing trial in the Sheena Pora murder case. Sir has gained mastery in the field of criminal trials through his marvelous skills of cross-examination and his unparalleled effort in the trials and other special laws such as Maharashtra Control of Organized Crime Act 1999. Sir was 3-time president of the Bombay City Civil Court and the Session Court. Currently, Sir is the member of Bar Council of Maharashtra and Goa.
बसूनच करायचंय नाही उभा करतो.
Now, I humbly request today's keynote speaker,
बुक किती
Sudeep R sir, please commence today's session on the topic integrity in practice, upholding professional ethics in the legal field.
नहीं कोई बात नहीं, मुझे माइक की भी जरूरत नहीं है यार. Hello friends, it's a privilege and a very memorable experience to be with you in the platform of Se Humdard. And the stories which have been narrated by our young man just now, which are heart-rending. It gives me more pleasure to be with you today and share some of the experiences which I have seen all this about 35 or 36 years of practice in my practice. Now today's topic which we have come, professional ethics. I'll tell you what is professional ethics. In a very common word, it is the dharma of a lawyer or of any professional. This is the dharma which a professional has to inculcate in his behavior. This is what he is required to practice and follow, not only to become a successful lawyer or a successful professional, but to succeed in life and make a mark for himself. Listen, for you, from when we start learning, our parents, our teachers try to inculcate good habits in us. Don't tell lies, do good deeds, help the poor, share your things with the others. So on and so forth, the things are told, and then you are molded in that character. Now the concept that is what is being told to you is also this, that these things you should develop your personality with these kinds of good habits right from beginning. So when you enter into a professional, now enter the profession, this thing, you are armed with the legal knowledge. Knowledge is a powerful weapon. That's a undoubted thing, that knowledge is one of the most powerful thing. And legal knowledge is, of all the knowledges, is the most powerful. Because you can do and undo so many things. You can do good deeds armed with the legal knowledge. At the same time, you can also do bad things armed with the legal knowledge. And therefore, these guidelines which form a part of ethics what is a professional ethics? It's just a collection of guidelines. And on the basis of these collection of guidelines, this professional ethics emerges. As I said, what I told you, this thing, knowledge is powerful, legal knowledge is more powerful. So therefore, you should not utilize your legal knowledge for, or misuse your legal knowledge, or you should not do anything good, bad. That is what for these canons are laid down. Now you are uniquely placed. Among other professions also there is etiquettes, there are ethics, there are rules and regulations. All professional bodies have disciplinary committees where they can disbar the member from the practicing in their professions. But a legal profession is unique in the sense that unlike from any other profession, the duties of a lawyer are multifold. You have a first duty towards constitution and upholding the law. You have a duty towards court. You have a duty towards your client. You have a duty towards public good. You have a duty towards the adversary. And ultimately, you have a duty towards justice. So these kind of, as I said, duties are not encompassed in any other profession. No other profession has got these kind of duties. It's uniquely for that is the reason why a lawyer, excuse me, why a lawyer has to develop and practice, understand the professional ethics when he enters into the profession. And I tell you one thing, lawyers who have kept themselves in the bounds of the professional ethics, who have there have been no reason for either the court, public, client or the adversary to make any complaint, have not only succeeded in life, succeeded in profession, but have shown, and therefore it is very necessary that you should, right from inception, when you enter into a profession, know what are the professional ethics. Now, as I said, professional ethics is multifold for a lawyer. And the first and foremost, professional duty towards the court, the constitution, the law. That's the most important. Now, duty towards the court. Now, duty towards the court is there will be hundreds of things. I'll give you a few examples also, but later on. There are a number of things. You have to be courteous to the court. At the same time, you have to be firm. You are not supposed to be servient. You are not supposed to say just my lord, and which is normally being done every day in the court. Nobody would like to cross path with the judge. But a lawyer is supposed to maintain the decorum of the court. He has to be polite. He has to be respectful. And this is one first thing. Besides that, when he enters the court, he should be properly dressed. This is one aspect which is properly dressed. He should be properly dressed. He should come in uniform. And he should be, at all times, should be properly attired. It should not be, we have seen number of times court lawyers come having their band going here, there, the buttons of their coat, this thing shirt open, or the coat being this thing not properly put up, the gown falling down, etc. Also, all these things. This is not proper. You should be properly and decently. It's not that you should be wear every day. You are supposed to wear a new white shirt and a new gray pant or a white pant. That's not necessary. But you should be decently dressed. So your decorum, and see what happens is your attire matters. But I'll tell you one thing, is not only a part of professional ethics, but if you are pleasantly dressed, even it pleases the court. It pleases your client, it pleases the other side, it pleases everybody. So therefore, you should understand the importance of being dressing properly. Now you also try to take note of that dress as a uniform which we have, which is prescribed by the Bar Council of India under the Advocates Act. Now this is unique. You have to wear it only in court. Wearing of uniform in any public platform is not considered to be a matter which would attract disciplinary proceedings. You know that famous lawyer, Mr. Sadavarth Gunavartane. Only yesterday, day before yesterday, I think on Tuesday, Bar Council of India has affirmed the order of Bar Council of Maharashtra and Goa, which was referred by the court. Justice Patel had referred the matter, where he had addressed a public gathering in court and banned. A public gathering outside the court premises, in court and banned, which was deprecated by the High Court. Referred to the matter was, he had filed a writ petition in the High Court. High Court refused to entertain that writ petition. The matter was heard by the BCMG. BCMG found him guilty of Rule 7 and he was debarred for a period of 2 years, and BCI has also upheld the order on this week only for 2 years. So you must understand the power of this. Why this is done? The power of it, because by this uniform, by this which you have on your body, the world at large takes note of it. The public at large takes note of it that you are an advocate. You are a part of a legal institution, and therefore you are not supposed to address this or wear this coat or band or this uniform while in any public platform. So whenever you go to a public platform, wherever you are addressing, please remove the band. Don't wear a gown. Wearing a coat, all right, I am also wearing a coat, doesn't matter, but you should not be in uniform. Uniform would be complete when you are with tie and band. So this is one, as I said, the first is the duty towards the court. Now there are, as I said, there are multiple where the duties are cast, and the rules, I will point out the rules. There are rules and rules made in this regard as to what is the duty of a lawyer towards the court. Now duty towards one lawyer toward the court is also one another thing, that to be fair and frank before the court, not to lie before the court or try to put forth the case of his client above the law. You have to argue, plead your case within the bounds of law. You can't put your client in front and then argue your case before the court. So this is another aspect where you have to maintain your duty towards the court. Now, duty towards the court is corresponding or to the duty towards your client. Now I'll tell you, when you come to the client and duty towards the court, there are certain duties which overlap, like touting, paying commission, or bribing somebody to get work. These are something which are considered to be misconduct. These are not. Now it is, as a young lawyer, when you don't find sufficient work to sustain yourself, to earn your livelihood, you fall prey for, some lawyers do fall prey for these shortcuts. Now when you fall prey for shortcuts, then you are making yourself vulnerable to disciplinary committees, being action under section 35 of the Advocates Act, and you can be debarred from work. So now this duty that you have, that you will not, and I'll tell you one aspect, one very incident, very long time back, there was an incident. That is it happened in a Kurla court with a very senior lawyer now, who's no more. When he entered the profession, all the seniors got hold of him, and he said that, all right, come, take oath before the court, before all in the advocate, that you will not tout, you will not pay the policeman, you will not entertain the this thing, etc. You will not pay anything for work. You will do your professional duty without bribing anybody. The poor chap took oath, and you would sit there in the bar room. For months together, he was sitting in the bar room, whereas all those seniors who had administered the oath to him would stand in the corridor and they pick up work from the touts. After 1 month or 2 months, I think 2-3 months, he was fed up from Kurla court and he had to shift his practice to other court. So these are things which will, when you enter into profession, you will find there are so many nefarious activities going on. Very bad habit things are going on, which are not very pleasant to, but then you have to keep away from them. Now this you will understand, because if you have inculcated this ethics in your this thing body, you have inculcated this thing, and you have taken an oath that I will, and I will practice within the boundaries of the professional ethics and not beyond that. So when you have, as I said, the duties which are towards the court correspond to the duties toward the client also. Now you have to be fair with your client. First thing, please remember, and I would request every lecture, even I say when I've given lectures, I say that always be fair with your client. When a client comes with a brief, take the case. Now you have to you have to do justice to the brief. You have to argue or whatever you have to do in regard to the matter to the best of your ability. You have to understand the matter, and when you understand the matter, you must make the client understand what are the pros and cons of his matter. Never lie to the client. Never assure him that results are would be good. Even if you know on the face of it, sometimes you say, oh, it's a cakewalk for me. I'm going to get, definitely there are hundreds of other orders and which are the judge is likely to follow. But things do not go as per your expectations. Please try to understand. Though there may be hundreds of precedents, but the court may differ on certain facts. The court may differ, and court may not pass an order which is appropriate or which is according to your expectations. So therefore, never ever assure the client of any result. Tell him even if it is a bad case, tell him on the face of it that it's a bad case, the chances of succeeding is less. And I tell you, if you are so sincere and frank with your client, one, you will not lose your sleep. Secondly, the client may take away the brief. It may be a case where the client may take away the brief. He said, all right, the lawyer is not promising any work, anything. Why should I give him work? He may go to some other lawyer who may promise him, all right, I'll get the result done and I'll get a favorable order. But don't be this thing. You please develop the habit of telling the client on his face that the pros and cons of his case, that according to me, you are not likely to succeed, but still I will take a chance. If you want me to take a chance, stick with me or go to somebody else. The reason is, I tell you, if you assure the client and the results are not as per expectations, then we have seen cases of violence against lawyers. We have seen cases where the clients have created ruckus in the courtrooms. We have seen how now even the social media. I've come across a case of a lady lawyer, where there are a number of social workers, in this thing, they have put up that this lady is so and so, and this lady is so and so. So this you can easily avoid, and maybe you will lose one or two brief, but ultimately it's your frankness and your correct approach and your proper opinion that would matter. And please, I'll tell you, after some time, your reputation as a lawyer, that this lawyer is sincere, he gives the correct advice, and people would be attracted to you, people will come to you. Those very clients who had taken away the brief earlier, they will return back to you with the briefs. So please understand, one, you have to be very, very frank with your lawyer. Secondly, as far as fees is concerned, there are various rules and regulations under the Advocates Act as well as in the rules framed by the BCI with regard to the fees being taken by the lawyers. Now, your charging of fees should be commensurate with your standing in the bar, as well as with the work which is entrusted to you. You can't charge a bomb for a small matter. You should charge a decent sum of money. Though Bar Council of India prescribes the fees, this is not that the fees is what is just a model form of fees it is. It is not the fees which is to be charged, or you can charge as per your expertise, as per your standard, as per the work, as per your qualities you feel. It's not necessary that you are a fresher and therefore you should charge less. If you are confident and if you are assured of yourself that yes, I can deliver the work, I can do justice to this matter, you can charge a reasonable fees. But then at the initial stage, when you have a less number of years put in the profession, then it is not appropriate that you charge a huge amount. There have been many cases, where we have punished the lawyers, where they have charged fees on crores of rupees, which was not commensurate with their standing at the bar. So this is one when you have to. So therefore, this also charging of fees is also a part of fairness towards your client. So you have to be fair to your client, fair to your this thing, and when you have given an honest opinion, you can honestly ask for him that this would be my fees. And as I said, never guarantee the result to him. Now, what happens is when a client approaches you, when a client comes with you a matter, he comes with a lot of expectations. He comes with a lot of belief in you. Is that all right? Let's take it. Let me take a chance with this young lawyer. Let's take it. He appears to be a very good in knowledge. Now, therefore, you must not take advantage of this. The confidence which he has reposed in you, that confidence which you have to maintain, that confidence, and you have to not see to that you don't breach that. Then the next thing was very important is the client and advocate, that privilege under. You have read section 126 of the Evidence Act. There is a privilege communication. The communication between, therefore you are uniquely placed, right? As I said, lawyers are uniquely placed. It is only communication between a lawyer and his client which comes within the privilege communication, other than the husband and wife, etc. No other profession provides for this privilege communication. Now, unfortunately, in view of this PMLA and other offences regarding this laundering of monies, etc., and then this narcotics cases and etc. In all these cases, now the question the government has been thinking in terms of disclosure. Penalty for disclosure. Now you have the chartered accountants, they get attracted if they do not disclose any fictitious the transfer of monies, or if they come across some fraudulent accounts, etc. They are supposed to disclose it to the authority. Now till today, there is such liability is not on the lawyers. We do not know what will happen in future. But today, the client and the advocate's privilege communication is a privileged communication protected under section 126 of the Evidence Act. And this you must retain. You must understand that whatever your client has told to you is in his confidence. He has a confidence in you. He has disclosed to you. Therefore, you must not breach his confidence. Now, I'll take one more aspect. One of this thing is one which is as I said, duty toward the court and duty toward the client. Sometimes they run parallel. They correspond. One of the duties which is a cast on the lawyer is not to refute any brief. Once you enter the profession, you become a member of a Bar Council of Maharashtra and Goa or any state bar council. You cannot and will not refuse any work which comes to you. You can only refuse work if there is a conflict of interest. You can refuse work if you have been representing somebody else in the matter, and then it appears to you that there would be a conflict of interest. Only then you can, otherwise you are duty bound to accept. You can't say this is all right, this is a murder case, this is a rape case. Lawyers don't do it day in and out, including I myself have been guilty of these things. But You are not supposed to do. That's what I'm trying to say. You are not supposed to do. If the client pressure says, no, sir, you have to take the matter, you have to take. This is not duty towards the client. This is your duty towards the court. This is the duty towards the constitution. And upholding law. That whatever work comes to you, I will discharge that work to the best of my ability, and I will not refuse, because just is a rape of a minor child. I suppose now all lawyers are reluctant to take matters of concerning a rape and murder of a minor child. All lawyers are. Then they will come with 100 excuses. Nobody says I will not take the matter because it's a murder case. They say, no, I'm busy in I'm busy in Delhi, I'm busy in Calcutta, I'm busy in Mumbai, I'm sorry, I'm this thing, I've got a operation to be performed, my family, my wife is sick, and all those things. 100 excuses you come out. But as I said, you are not supposed to, but you can't say blindly, no, I will not take this matter because this is something which is heinous to me, or this is a rape, this is. So many lawyers don't take that case of prostitution. So many lawyers, we also don't take cases of prostitution. But then we give a different excuse altogether. But you can't refuse just because there is a case of a prostitution that you I'll not take up a matter. So because this is a duty towards law, duty towards the profession, duty towards the court. So you have to follow this. Now this is the basic setup. One, which I would say being fair to the client, being honest with the client, accepting whatever work he comes to and will say, and maintaining the confidentiality. These are the things which are required, basic things which are required for a lawyer to start with. There are, as I said, when you go and there are hundreds and hundreds of things which have yeah. Now there's also, they say you can't retain the brief or the documents of a client just because he refuses to pay fee. There are landmark judgments on these cases. You can't retain that. You have no lien over this matter. You can claim. You can file suit against him. Claim your fees. But you can't claim a lien over that matter. Now I'll tell you one thing, and which is the principle which I have followed in my life. If any client, by chance, there would be very far and few, who would be dissatisfied. And normally the client is dissatisfied at the end of the matter when the result is not in his favor. So he gets dissatisfied. Till the time everything is peaceful, nothing no wrong. Now he might be Now whenever a client feels this thing, after the matter is over or this thing, that he is unhappy with it, return his paper, return his brief, and be happy. Because you have to buy peace. Sometimes you have to buy peace. You can't fight with everybody. There will be, particularly in a criminal matters, where the client would be a criminal. You can't fight with a criminal. And sometimes he may be a petty criminal. Why fight with a petty criminal? All right, take your brief, take your money, go back. If you are not satisfied, nothing. Whatever I did for you, I did out of charity. I follow this principle all my life, and I have been doing it. Momentarily you feel bad. You momentarily feel that you have been cheated by the client, you have been deceived by the client, you have been taken for a ride by the client, and you have done your best, and still you have required to return his fees or return a part of the fees, etc., etc. But remember, he goes happy, you are happy, and work is going to come this thing. Other clients are going to come. He's not going to badmouth you. He's not going to tell everybody that this man has not done. So try to understand in that way. You have to be what you have to. What are the larger gains by these things? Don't fall for any shortcuts. But if you fall for shortcuts, when you fall for shortcut, then there's a very deep fall. You will fall for many other things when you go for a shortcut. So the idea is, and what these collective guidelines which we follow in the professional ethics is that keep the client happy. If the client is happy, you are happy and you are successful. Now, as I said, duty towards the court, duty towards the client, and then the third is duty towards law, duty towards constitution. Now, One thing when you remember this thing is how do you do your duty towards law, duty towards practices, to keep abreast with what is happening in the courts, what are the latest judgments, what are the latest legislations, and apply them to the facts of your case, to the case which is the brief which comes to you. This is very primary, which is required to be done with this thing. You are ultimately upholder of constitution. You are an upholder of law. The law. Therefore, you are a very important stakeholder. Therefore, you have to be very, very keen student all your life. And to be a keen student of your life, you have to spend some hours of the day in reading. Inculcate the habit of reading. I would request everywhere today. What is happening, unfortunately, with all this electronic media and other things, we are losing the habit of reading. I used to have a very large library. I still have a very, very large library of books unconnected with law. Totally unconnected with law. My passion has been history. Though I have never been a student of history, my passion has always been a history. I have a large library of history. But I myself have not bought a book for last 2 years. Because gradually, now so many things are coming in Netflix and YouTube and everything that you are seeing every day. You don't feel like reading. But at this young age, I would request you to read as much as possible, because you may not find everything. And ultimately in social media and other things, the truth and falsehood are so intermixed. You cannot be with this. Ultimately, history always falls prey to these kind of things, the way it is projected. So you will not know the correct things which is happening. So I would request you to read, be a student, keep reading, so that ultimately, which is one of the foremost duty, that duty towards law, you can perform successfully. Now, duty towards law comes after the duty towards the law and this thing. You have to, as I said, there are so many things. Duty towards your adversary. Don't you have a duty towards your adversary? As you have a duty towards court, as you have a duty towards constitution, as you have a duty towards your client, you have a duty towards your adversary also. You have to address him properly. Never insult him or abuse him. Speak to him with respect, because respect is earned. If you give respect, he is bound to give you respect. So address your adversary. Never meet him in the adversary, or discuss the case in absence of any instructions from your client. If the advocate from the other side or the adversary approaches you with something, tell him, I will get back to my client. I will put forth the proposal, and if he says okay, we'll take it forward. But never make any commitment to your adversary or offer any reward to the adversary. Don't try to this thing. Do you see, normally in civil matter, sab apna vakil big gaya. This is all happens in a civil matter. When the matter is the end of the day, when the suit is dismissed or suit is decreed in favor of the other party, then they always says apna lawyer ko mil gaya dusre side se. These are all very common, and this is going to happen. People will talk loose. That should not disturb you. But you should not give an opportunity for somebody to raise a finger regarding your conduct by meeting the adversary behind the back of your client, or exchanging any messages. Today's world, everything is on WhatsApp, email, etc., on SMS, everything is recorded. Why give an opportunity to somebody to make this kind of allegations? So avoid it. See to it that he doesn't do that nobody can raise a finger regarding your character and this thing. Now these are, as I said, ethics mold your character. These ethics which you follow will mold your character, will mold your profession. Your reputation will be based upon this ethics. beyond, no lawyer has succeeded or has got a good reputation in breach of the professional ethics. Many intelligent lawyers, many intelligent lawyers who have committed breach of professional ethics could not achieve high offices. They could not become judges and be elevated to High Court and Supreme Court because of breach of professional ethics. And whenever you come to this thing, whenever you apply for any post, first thing they verify whether there is a case of professional misconduct against you. Even as for today, that this thing, thousands of thousands, 10,000 or 14,000 notaries were appointed. 14 or 17,000 notaries in the state of Maharashtra were appointed. Each of the notary was required to get a certificate from Bar Council of good standing. When you apply for a post of a prosecutor, when you apply for a post of a judge, when you apply for any post, you are required to have a post. And this is only when you are in compliance with the professional ethics, which is, as I said, demanding, but you are required to follow. Ultimately, it's a thing which gives you some impetus in this profession, which gives you respect in this profession, and you can achieve greater heights by following these kinds of professional. I'll tell you very few things which I had noted down for our young, which you must remember and which I just jotted down very hurriedly after returning from office yesterday. There are 5 principles, please try to understand. Confidentiality and attorney-client privilege, which I just spoke about to you, section 26. Competence and diligent representation, which requires a lawyer to maintain a very high standard. Now, competence and diligent representation. Now, you take money. It's not that I take money, I don't read the brief, I don't prepare myself, I go to the court and start mumbling something, the judge fires me, the matter is over. That is not the representation. It's your duty to diligently represent, and you can diligently represent only when you are prepared in the matter. See, the performance and the preparation will differ from lawyer to lawyer. The presentation will differ from lawyer to lawyer. But ultimately, competence is something which you should be, that you have competently put forth as something and work diligently. Then avoid conflict of interest. As I said, avoid conflict of interest. There are, in the Bar Council rules, if you see, there are a large number of rules framed as far as how to avoid and what conflict of interest are you required to avoid. And when you become successful and become a senior lawyer, you will find that these conflict of interest happening very frequently. Because people come to you, and I'll give you an example of that as far as conflict of interest. When you have a particular standing in profession, young lawyers or even lawyers put in some number of years of practice, they will approach you in the corridors, in the washroom, or in the bar room, in the library, with some problem, with some matter, discussing some matter. Now, as a lawyer brethren, you can't say that I'm not going to give an opinion unless you pay me or you come to my office, deposit money, I'll give you opinion, then only. You give fairly opinion, you look at, all right, this is the thing, you have to do this thing, that thing. Now what happens the next day, the other side comes and approaches you. You have already given opinion to some other person. You have not charged a paisa for it. It is only a friendly advice which a lawyer, a co-professional practicing in the same bar has approached you and asked for an opinion. What do? And then your client comes and says, no, look at the matter. Are you going to refuse the matter? Tell me, what are you going to do? Are you going to refuse the matter? Or are you going to take up the matter? Ethically, you can't take. But practically, yes. There's no problem in taking it. Because you have neither given any written opinion to him. You have not charged him. It was only a casual talk between one professional with the other. So these kind of, as I said, when you have sufficient number of practice, when you have some reputation at the bar, these things will happen very frequently. And sometimes the other side may take objection also. Sometimes in the court they may take an objection. That, sir, my lawyer had spoken to you about this matter. You can't appear for it. It has happened. Now then there's a two-way. Either you withdraw yourself or you say, no, nothing doing. You have not paid me anything. You were not there when the matter was discussed. Even if you were there, nothing. There was just a casual talk about a matter. That nothing prevents me from representing such a law. Now this is what, as I said, this will happen at a late stage, but you should be wary about it. Professional courtesy. Now professional courtesy, as I said, courtesy toward your opponent. Not only this is something which is good and which will earn a reputation for you, but also creates a very healthy environment. Then there's another duty which you should also, duty towards pro bono cases. You have a duty towards pro bono. You have to do some this thing. Of course, the Supreme Court and our Chief Justice Chandrachud, in number of speeches, in Justice even Gawai in number of speeches have said that lawyers should take up minimum number of some matters, five matters in a year as pro bono cases. Everybody will do that pro bono cases because sometimes a matter will come through a friend, sometimes it will come through some relative, somebody said, all right, he's a poor, he's my domestic help, he's my driver. Do that, you do work the pro bono cases. So do some pro bono. It may not be fully pro bono. You may take some expenses or you may take something, but try to do some pro bono work. This is what, if you do this kind of pro bono, this is expected under your professional ethics that you would do this kind of. Now I'll just tell you now, there are certain prohibition. Under the Advocates Act 1961, the rules which have been framed by Bar Council of India that you would know, there is a prohibition for advertising and soliciting work. Now, times have changed. Social media has come. When these rules were framed, there was no social media. The advertising was in infancy. But now you'll find lawyers in various, and there are petitions pending here in the High Court, there are petitions pending in Supreme Court, there are DC files against number of lawyers here for advertising and soliciting work through the social sites. There are sites there are certain sites which offer work, that all legal work will be done by them. To all lawyers, this is some kind of an insurance scheme. There's some companies have come out with an insurance scheme to doctors who face the maximum number of matters as far as both in the consumer court as well as for medical negligence cases. In those cases, now there are companies which are giving them in complete insurance that all your court matters will be looked after by us. You just pay your yearly premium. Now they have advocates on their roll. The moment any doctor who has taken this policy faces any case of medical negligence or any complaint in a consumer court, he has to just inform that the company, and the company will appoint a lawyer for him and will do this work. Now this kind of, as I said, soliciting work through advertising and other things, this is one thing which the Bar Council, the Government of India, because ultimately the Advocates Act will have to be amended, they are looking into seriously. Because if you see abroad, particularly in Western democracies, and very peculiar to USA, the lawyers are free to advertise. If you check in any hotel in the US and you start the TV, first 10 minutes you will only get advertisement of lawyers. then you may get some channel. Otherwise, all the programs of advocate, practice, expert in medical negligence, expert in accident case, expert in matrimonial matters, expert in these kind of matters, so on. So advertisements go. Then the next is prohibition of demanding fees for training. Now, when you become a senior and you have interns, juniors, etc., you can't demand. Initially, what has happened was, why this has come into in British time, in England and other places, even in US, to certain extent in certain states in US also, the lawyers would keep interns or juniors subject to their capacity to pay them. I am training you. I am giving you knowledge. I am making you an experienced lawyer. Therefore, you have to pay me. Now, therefore, when this and the Advocate Act 1961 was formed, and the BCI rules were formed, this was one concept that all the lawyers will not charge. Till that time, even in India, the senior lawyers were charging fees from their juniors and from their interns for giving them training. So now this is totally prohibited. Then third is consent for entering appearance. Now this is also a contentious issue. In a civil matter, yes, you are required to take a consent of the other side before appearing. But in a criminal matter, it is the choice of an accused, choice of a party to engage any advocate. The question is, is it necessary for a lawyer to take the consent of the other side? And here the professional ethics come into. Ethically, morally, you are required to take consent of the other side. And then the last prohibition is unauthorized use of your services. You have seen movies, the Hollywood movies, all gangsters, you have seen the Chicago gangsters, they would have one lawyer. So this is what is that you don't use your knowledge. There have been many famous lawyers in USA who are on the payrolls of the gangsters, the mafias, the Chicago mafia, the New York mafias. So even in India also this is unfortunately there are lawyers on the payroll of the criminals. But this is a prohibited thing which you should not, because you are misusing your knowledge to help an accused. Though sometimes, as I said, even if you have frank opinion which you gave or frank advice which you gave may fall and you may attract some legal liabilities or some police action, etc. But don't. As I said, you have to give your fair opinion, free of anything. You should not use your knowledge or misuse your knowledge for the purpose. Then the next is, as I said, you can't refuse a work. You also cannot unilaterally withdraw from a matter. Once a matter is interested to you, whether it's civil, whether it's criminal, whether it's or of any kind, you have to discharge, because your duty is towards the court first and foremost, rather than the duty towards your client. So you can't unilaterally discharge. If you have some fallout with the client, you cannot say that I'll not appear in your matter. You have to seek the leave of the court for withdrawal from appearance in the matter, and only if the court allows you to withdraw, then only you can withdraw. Even in that case, I tell you, in that case, even a very famous lawyer, he was not paid his fees. There was some dispute regarding the payment of fees. He appeared before the High Court and asked the Lordship for permission to withdraw. The court permitted him to withdraw. It's a court order permitting him to withdraw. Still, the client prosecuted him for breach of professional misconduct. for committing professional misconduct, and he was held guilty of professional misconduct. So even otherwise, even if the court permits you, if it is not to the liking of your client, you can't say that I'll go and withdraw myself. Then one last thing which I would like to tell you about is, which I feel is very important, and which is the foremost duty of not suppressing any material. We have come across many cases where advocates have been reprimanded by the court in open court for either telling a falsehood, trying to suppress the material from the court, or trying to mislead the court. So this is one of the very serious misconduct which a lawyer can do if he suppresses the material. But I am sure all of you will in your practice follow the ethics sincerely. All these collective guidelines which are given under the Chapter 2 of the Bar Council of India rules. Of course, some of the rules are really extreme and some are not workable, and therefore I have not even discussed those things. But read those rules, understand the rules. As I said, once you understand these four basic concepts of yours, that what is your duty towards, last which we have remembered, the duty towards the nation, duty towards the community, duty towards the public at large. Now, what is this duty towards public or duty towards the community? Is following this ethics sincerely, upholding all these canons of professional ethics, so that people look with awe at a legal professional, a lawyer, with respect and with dignity. You should not do anything whereby the dignity of a lawyer or a dignity of the legal practice is tarnished. So that is one of the last which I would say canons which you should follow. See to it that whenever, see, you are a lawyer 24 hours. You may not be a lawyer in court, but even outside the court, your conduct outside is also judged in the light of your profession. And therefore, even when though you are not in dress, whenever you are not in uniform, when you are not practicing, still you should be respectable, dignified, so that the image of a lawyer, unfortunately for some reasons, for some few black sheeps, this profession sometimes get tarnished. But then you must overcome it. You must see to it that it does not happen at your hands. Thank you very much. Thank you, Mr. Prakash Salsingekar sir, for inviting me and refreshing myself in professional ethics. Thank you very much. Thank you for coming. Any questions? If anybody has any question?
Thank you so much, sir. The way you presented today's topic, that is practice, ethics, and professional ethics, it's very easy and very engaging for us. Till today we have read only ethics, but from now we come to know how to apply in the legal field while practicing the law. Now I would like to start the question answer session. If anybody has any kind of question, you can ask this sir.
Yes, please.
So as you said that advocates are not supposed to advertise and promote themselves. But many of the lawyers use, the advocate sign on the card. So does that come under this
It comes, it does come. There have been, but then it is so. If you go not in Maharashtra, but if you go across the country, you'll find everywhere in the two-wheelers and this thing you'll have an advocate. But that it is only to identify yourself as a lawyer. That may not strictly come within the definition of advertising yourself.
Anyone else? No questions? Okay. So, I would like to call Aarti for the vote of thanks.
एक है कौन?
गुड इवनिंग सर।
Good evening.
सर आपने बोला
हाँ 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 बिल्कुल.
सर आपने बोला कोई केस आएगा तो बदल जाएगा स्टेट रिपोर्ट में लिखा है एक्टिंग आ गया अपने पास
Accused, I'll tell you one thing. Accused तो आएगा तो crime. See, when an accused comes, एक accused आता है, उसके ऊपर कोई गुनाह का आरोप है. 99 टाइम्स तो उसने किया होगा. एक टाइम होगा, 1% चांस होगा कि उसको बेगुनाह होगा, उसको झूठा केस में पड़ा. You are not to judge him. आपको उसको जज नहीं करना है कि तूने गुनाह किया है. ना आपने उससे पूछना है कि तूने ये मर्डर किया, तूने ये गुनाह किया. You are not supposed to ask. Please try to understand one basic thing. आप मैटर आपके पास आया, मेक योर ओन जजमेंट. अपना जजमेंट लगाइए किसने किया है या नहीं किया है. आपको ऐसा नहीं है कि वो बेगुनाह है तो ही मैं मैटर लूंगा. उसने गुनाह भी किया है, वो आपके पास अपना केस लेके आया, वो अपना बचाव करने के लिए, जिसका उसको संबंधित अधिकार है, तो वो अपने बचाव के लिए आया. आपको अपने केस पेपर से उससे संबंधित है. आप उससे पूछिए नहीं कि तूने कैसे किया, कहाँ किया, क्यों किया. इससे आपको कोई मतलब. जहाँ इंस्ट्रक्शन के टाइम पे हो सकता है आपको पूछना हो कभी केस चलते हुए कि भाई क्या हुआ था, कुछ बता. वो सच बोले या झूठ बोले. नहीं साहब मैंने कुछ नहीं किया, वो तो सामने वाले आए थे मेरे पे अटैक करने के लिए, मैं तो जब बचाव कर रहा था, चाकू उसके ही हाथ में था साहब, मैंने तो ऐसा. वो ऑल दिस थिंग यू डिड नॉट जस्ट अंडरस्टैंड द मैटर, दैट्स ऑल. मजाक मजाक में आप पूछ सकते हो, लेकिन ऐसा कभी कभी क्लाइंट से ये मत पूछिए कि आपने एक गुनाह किया है कि.
थैंक यू
सर
हाँ बोलो ना.
wrong reply or say false reply for legal notice on an advocate, corporate advocate, falls under this ethics, sir?
Yes, it will definitely, if it is wrong, yes. But question of wrong and right, it's a subjective thing. आपकी नज़र में बोला ये तो गलत बोला है, उसकी नज़र में हो सकता है सही हो. So these are subjective things. Ultimately, yes, अगर उसने
attending the point wise
हाँ नहीं विदाउट अटेंडिंग पॉइंट वाइज वगैरह, या उसने कोई जवाब दिया जिसका जो सरासर गलत है. एक तो पहली बात वो एक्यूज वो अपने क्लाइंट के इंस्ट्रक्शन पे नोटिस दे रिप्लाई कर रहा है. उसका ये रिप्लाई उसका खुद का रिप्लाई नहीं है, ये क्लाइंट का रिप्लाई है. और एज आई सेड ये तो सब्जेक्टिव है ना, सच या झूठ. इट डायरेक्टली और एक्सप्रेसिव विल नॉट अट्रैक्ट एनी डिसिप्लिनरी कमेंट.
के बारे में सर
It is not ethical. It is not ethical absolutely to tell lies if you know that your client is lying to reply in the notice. आपने बोला उसका, लेकिन but you are acting under his instruction. You know that it's a lie. So you have to mold that lie in such a way that it is not a lie.
As we approach the end of our program, I'm pleased to invite Aarti to deliver the vote of thanks.
On behalf of all of us here today, I would like to express our sincere gratitude to Advocate Sudeep Pasbola sir for taking the time to deliver such an insightful lectures on integrity in practice, uphold professional ethics in the legal field. Sir, your presentation was truly enlightening and knowledgeable. We are honorable to have you with such extensive knowledge and experience that you share ethics in the legal field. Sir, thank you for making time for busy schedule and share insight with us. I would further like to extend my heartfelt gratitude to our anchors and our volunteers who have worked effortlessly to make this event a success. I would also like to thank all the participants who took the time to join us today. Your active participation and engagement in this session has made it even more worthwhile. And also thanks to Team Renovate India. Once again, thank you all who were involved and we look forward to such more future events. Thank you.
Thank you.